Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Law of Torts. Dear students, yesterday in the class I told you I just touched the topics of damnum sine injuria and injuria sine damnum. Damnum sine injuria means damnum means damage, sine means without, injury. Injury means, please remember, legal injury. Some wrongful act should have been committed and that should have resulted in damage or legal injury to the plaintiff by the tortfeasor. So if the damage is without any legal injury, we can't help. The judge will say simply, it's not a tort, go out. But here the other concept is injuria sine damnum. Don't get confused, these are all Latin words. Injuria sine damnum means injury without damage. Legal injury is there, but no damage. Still, it is a tort. I am going to give a classic example for this. Injuria sine damnum. That means injury without damage. When legal injury is there, when somebody violates your right, when somebody infringes your right, definitely you have got a right to get remedy basing on the principle of ubi jus ibi remedium. Ubi jus ibi remedium. I have given a reply, an explanation for that in my notes also. When a wrong is committed, where there is a wrong, you have got a legal remedy, rightful remedy. So for the injuria sine damnum, I am giving a classic example of the case of Conten, Constantine, Constantine, Constantine versus Imperial London Hotels, 1944. You may be knowing Learle Conten was a famous cricket player. Of course, he was an African American. Actually, he is from Bahamas or Trinidad and Tobago, Trinidad Island. He used to play for West Indies, but he lived in UK. Right, he traveled to London to play in some case, to play for Dominion team against England at Lords. So, he has already booked room, he and his family members. They had a reservation to stay in Hotel Imperial Hotel, London at Russell Square. Please remember, he was assured that he and his family will be welcomed and treated with the utmost respect. But when they arrived at the hotel people, please remember, they informed them that they could stay only one night on account of the complaints about their presence with the white Americans. There was racial discrimination at that particular time. They said, why these niggers? Then he felt humiliated. He has already got reservation. So the management then realized and they said that, sir, because of the white Americans, we are not able to accommodate you. We'll give you another beautiful accommodation in our other hotel. Please go there. Then he felt, please remember, Conten was outraged. Here it was written, Conten was outraged. Then it is nothing but breach of contract or the legal injury, that is tort. He filed a case of tort. Please remember, the hotel committed a tort deriving from the common law principle that innkeepers must not refuse accommodation to the guest without cause. This is what is stated in the case law. That's why I am repeating the word. Anyway, please remember Justice Brickett, who heard the case. So, the right of Conten time for stay in the hotel was violated. The innkeeper had a reasonable duty to provide accommodation, and the contention that they would provide alternative accommodation was not at all allowed by the court. So, of course, he was awarded 5 Guineas in damages. Whether it is 5 or 12 is a different thing, but this case has become very popular after Ashby versus White case. Ashby versus White, very famous case. Of course, it happened in the year 1703. Later in 1944, this is another very, very important case. So, if you find time, please go through the case law and enrich your legal knowledge. With this, I am concluding. Thank you very much.